Dating websites, hey, they exist. Lots of people use them, but what happens when the representations made on the website are untrue? Well, that takes us to this week's case. It involves a real man, mid-50s, in California. Signed up for a website. It was positivesingles.com. And it was a website that was designed for people who had sexually transmitted diseases. When he signed up for the website, he, of course, clicked on one of those normal, sometimes referred to as wrap agreements, where it says, I agree, I disagree with the terms of service. Clicked on that, and there were representations that said the information that is going to be submitted is going to be confidential. Well, he later finds out that the information wasn't confidential. It was posted on various other websites, and the whole purpose of the website was just to gather information, then bundle it together, use it for marketing purposes and a variety of other things. When he became aware of this, he was really distressed. And he brought suit. He brought suit against this website and against the website that owned it, which actually is being operated out of Chengdu, China, even though the company was incorporated in California. Well, on behalf of the company, the lawyers argued, hey, wait a second, when you signed that agreement by clicking on it, and you said, I agree, well, part of that agreement said we had the right to disclose information. The other comments that were on the website dealing with, hey, this is going to be confidential, those weren't guarantees, those were simple puffery that were given in an effort to try and have people sign up for the site. The guy said, no, I don't like this at all, I don't like this at all, and he moved forward with the suit. Part of the suit was based upon the California Consumer Legal Remedies Act, which provides remedy in cases like this. Long story short, he argued the information had been disseminated widely. They argued when you post it on the World Wide Web, it's going to go all over the world. He said, I didn't know it was going to go all over the world when you guys were reposting this information. I have really been damaged by this. A lot of people become aware of stuff I didn't want them to become aware of. You've been using it for marketing purposes. This is a bad deal. Well, the jury heard this when it went to trial. Jury heard this, heard the various arguments on both sides, and when they heard the arguments, they in fact voted in favor of a verdict. And the verdict they voted in favor of was in favor of the fella that brought the suit. The jury found that the website acted very badly, that in fact it did disseminate this information without permission, and that there had been a guarantee on the site against sending this stuff out and violating rights of privacy. When the jury was upset, the jury did what juries many times do, and they voted in favor of a very large verdict of over $15 million, over $15 million. Okay, so that's where the case is now. Now, where's this case going to go long term? We don't know. We don't know. Generally, 2 out of every 3 cases that are appealed with large verdicts, the verdict is reduced. Also, this is a company that, gee whiz, might be a little bit of a fly-by-night company. They could go bankrupt and disappear, leave the country, and leave him with nothing but a piece of paper to try and collect a verdict. Okay. So, what do we learn from this case? What we learn from this case is an important thing, and that is when you sign up for various websites, be aware of what you're signing up for. Now, in this instance, that didn't play as big a role as it could have, but when you agree to the terms and conditions, you better understand what you're agreeing to. And secondly, it demonstrates that when a website violates its general representations, that website can be held responsible for a violation of those representations. Okay, we bring you this case as we bring you cases every week so you understand how the law works. I'm David Allen.